Good morning or afternoon, depending on where you're joining us from, and welcome to our webinar, Insights on the Impacts of Firearm Laws on Intimate Partner Violence Outcomes. I am Erin Hagan, the Deputy Director for Evidence for Action, and I'll be your moderator today. Our mission at Evidence for Action is to support rigorous research evaluating which strategies are most effective in improving population health, well-being, and equity. Today we're excited to share with you findings from research we funded examining the impacts on intimate partner violence and homicide of state laws prohibiting individuals subject to domestic violence-related restraining orders from possessing firearms. To give you some context about this issue, over 1,800 people in the United States are killed each year by their intimate partners, and approximately half of those homicides are committed using firearms. Research has shown that when perpetrators of intimate partner violence have access to firearms, the risk of these sorts of homicides increases fivefold. Because of this connection between firearm access and intimate partner homicide, regulating the possession of firearms by offenders is one approach to reducing these types of homicides. As you'll hear today, the framing of these laws is particularly important when it comes to enforcement methods. We're joined by two experts in the areas of gun violence and intimate partner violence, Dr. Michael Siegel and Dr. Emily Rothman. Dr. Siegel is a professor in the Community Health Sciences Department of the Boston University School of Public Health, and Dr. Rothman is an associate professor in the Department of Community Health Sciences as well at Boston University School of Public Health, with appointments in the BU School of Medicine and the Department of Pediatrics and the Department of Emergency Medicine. And Dr. Rothman her expertise spans the areas of intimate partner violence, sexual assault, human trafficking, firearm violence, and pornography. So at this point, I want to turn it over to Mike to get us kicked off. We have quite a bit to talk about today, so let's jump right in.
Well, thanks, Erin. I want to start by talking about just giving a background to what the federal law is regarding firearms and intimate partner violence, because it's important to understand the federal law before we can understand what state laws are needed to address the loophole. So basically there are three federal laws regarding firearm possession. The first is the Gun Control Act of 1968, and that makes it illegal for anyone to possess a gun who has committed a felony. So that covers intimate partner violence felonies. The law does not specifically mention intimate partner violence, but it does cover all felonies. So anyone who commits an intimate partner violence felony would be covered under that law. The Violence Against Women Act of 1994 added a restriction on firearm possession for people who are subject to permanent restraining orders. And then the Lautenberg Amendment of 1996 added a firearm possession prohibition on people convicted of intimate partner violence misdemeanors. So that's the landscape in terms of what the federal law does. But there are some loopholes or problems with the federal law. And the most important is that it's very difficult for states to enforce federal law without having a statute of their own. Certainly federal law enforcement officers are not going to get involved in tracking down every intimate partner violence offender in all 50 states and making sure they don't have access to firearms. So it really is something that the states need to enforce. And for effective enforcement, states have to have their own statutes, which enables state law enforcement officials to do the necessary enforcement. So for that reason, many states have codified federal law into their own statutes, essentially taking the federal law and just putting it into their own statutes by passing it as a state law. And that certainly helps with enforcement, but doesn't solve the problem completely because there are a number of loopholes in federal law. First is that federal law does not cover dating partners. So if someone is has committed a intimate partner violence crime, but is a dating partner of the victim, they are actually not covered by the law. And the same is true of people who are subject to restraining orders. If it is a dating partner of the person who obtains the restraining order, they're actually not subject to the federal law possession restriction. Second, it doesn't cover temporary restraining orders, so it only applies to permanent restraining orders. But this is a problem because it takes a while for the hearing to be held, and in the meantime, that can be one of the most dangerous times. Third, it doesn't cover stalking offenses. Fourth, it doesn't require that firearms be removed from an incident of intimate partner violence. So basically, nothing can be done at the incident. Nothing can really be done unless a restraining order is obtained or criminal conviction is made. It doesn't explicitly require the surrender of guns that are already owned by offender. So it basically will prevent the offender from purchasing a new firearm. But if they already have firearms, the federal law doesn't do anything to actually require offenders to give up or surrender firearms that they already have. And finally, it doesn't authorize or require law enforcement to confiscate guns if they are not turned in. So various states have filled in one or more of these loopholes by not only codifying federal law into their state laws, but strengthening the federal law in one of these or more of these areas. So there's kind of a hierarchy of enforcement of these provisions that we coded in these laws, starting with no possession of firearms and progressing kind of forward in 3 different steps. And the first step to strengthen that is a requirement that offenders must relinquish firearms that they already have. That ensures that not only does the offender, not only are they unable to purchase a new firearm, but any firearms that they already have, they're going to have to surrender. Beyond that, the next step would be law enforcement having the authorization to confiscate weapons if an offender does not voluntarily surrender their firearms. And then finally, the most stringent enforcement provision is one that actually requires law enforcement to confiscate weapons within if a offender doesn't turn their weapons in a certain period of time. So the backdrop to this research is that really no previous study, a number of previous studies have looked at these domestic violence related firearm laws to see whether they're effective, but none of these laws looked at these specific enforcement provisions to see whether or not they make a difference. And so the purpose of this research was not only to examine the impact of state firearm laws on intimate partner homicide rates, but to examine specifically the role of these various enforcement provisions to see whether they make a difference. Very briefly, the methods are that we use data on intimate partner homicides from the FBI supplemental homicide reports, and we derive data on state firearm laws for all 50 states from Everytown for Gun Safety, and we coded these laws as part of a larger project funded by the Robert Johnson Foundation, and that is our state firearm law database, which is publicly accessible at statefirearmlaws.org. So if anyone has any questions or wants to look up the status of any of the laws that we're discussing today, you can actually go to that website and get any information about the status of those laws in all 50 states. We did cover all 50 states in our analysis, and we covered a 25-year period from 1991 through 2015. So here's the findings looking at each law separately. So the first type of law we looked at were laws that prohibit possession of guns by people who have been convicted of a misdemeanor crime of domestic violence. And we separated that into 2 different categories. One are laws that prohibit gun possession but do not require relinquishment of weapons. And the other are laws that not only prohibit possession of guns, but require the offender to actually relinquish guns that are already in their possession. And you can see that we found that these laws led to a reduction in intimate partner, this is firearm-related intimate partner homicide rates, but these were not statistically significant reductions. We then looked at intimate partner violence restraining orders, and again we divided them into two categories: laws that did not require relinquishment of firearms, and those that did require that people subject to restraining orders turn in the guns that are already in their possession. And there was a small decrease in firearm-related homicides among in the states that had the restraining order law without the relinquishment requirement, but it was not statistically significant. However, in states that not only banned possession of firearms by people who were subject to restraining orders, but also required them to surrender their weapons, there was a very large and statistically significant reduction in firearm homicide rates, a 15% reduction. We also looked at laws that require removal of firearms from intimate partner violence incidents, and we didn't find of an effect there. We also looked at this was looking at laws that require that only some firearms be removed from these incidents. Unfortunately, not enough of the states have passed laws requiring the removal of all weapons from the scene of an intimate partner violence. And so we couldn't examine those laws. There just weren't enough to look at those. And finally, with the stalking laws, we also did not find a significant effect on intimate partner homicide rates. So the major finding of this study is this 15% reduction in firearm-related intimate partner homicide rates in states that have laws that ban possession of firearms by intimate partner violence, people who are subject to restraining orders, and also require that those guns be surrendered to law enforcement. And just to give you a little bit of a sense of what that translates into, we estimate that if all 50 states had these laws in force, there would be approximately 120 lives saved every year because of those laws, based on the results of our model. So we basically, before I get to the conclusions, I just want to address one very important question, which is, does this mean that all the other laws are ineffective? Does this mean that the only law that works are laws, these restraining order laws? And the answer is no. It's important to recognize a couple of things. The first thing is that just because we didn't get a statistically significant result doesn't necessarily mean that the law isn't effective. We only had some of these laws actually did look like they were reducing intimate partner homicide rates, but our sample size is not really big enough. Not enough states have enacted some of these laws to get statistically significant results. So definitely shouldn't take away from this that some of these other laws are not effective. But more importantly, it may be that the laws are simply not strong enough. So I think rather than just concluding that these other laws aren't working, I think what we have to look at is, are these laws strong enough? Do they have the teeth to them? In other words, the enforcement provisions that would be necessary for them to be effective. And then finally, it's important to recognize that these laws, there are many reasons why these laws are justified, even in the absence of a finding of a measurable decline in homicide rates. There are reasons why someone, for example, who has been convicted of a misdemeanor crime of domestic violence should not have access to firearms. And it doesn't necessarily rely upon demonstrating in a study that there's a significant effect of that to justify such a law. So that needs to be kept in mind as well. But basically the conclusion of our study is that laws that prohibit firearm possession by people subject to intimate partner violence-related restraining orders and require them to relinquish weapons that they already have appear to be effective in reducing intimate partner homicide. And from that, it appears that building enforcement into state firearm laws is an essential strategy to ensure that these laws have their desired impact. So I want to give you a little bit of an overview of what the landscape looks like in terms of how many states have these various laws in effect. So this shows you the trends from 1991 through the present in terms of the number of states that have laws prohibiting firearm possession by people convicted of misdemeanor crimes of domestic violence. And you can see that there's been a large increase, and that the increase continues. In fact, more than 25 states, we're up to about 28 states now, so more than half of the states have these laws in effect. Similarly, with laws that prohibit firearm possession by people who are subject to restraining orders, there's also been a large increase, including over the last 4 years, a particularly striking increase. And again, we're up to about 27 or 28 states. So more than half of the states have these laws in effect. But it's important to recognize that there's a big variation in terms of the enforcement provisions. So here's the total number of states that say that if you're convicted of a misdemeanor crime of domestic violence, you cannot possess a weapon. But how many states actually require that you surrender weapons that you already have? And you can see with this purple line that it's a lot lower. Only about half of the states that have the misdemeanor crime law in the first place have the surrender law. And then if we go one step further, how many states actually authorize law enforcement to confiscate weapons if a person doesn't voluntarily turn them in? And you can see there with this green line that it's much, much lower. In fact, there are only 2 or 3 states that have laws where if someone doesn't turn in their weapons in a certain amount of time, that law enforcement is actually authorized to go and confiscate those weapons. And the pattern is similar with the restraining order laws. So again, there's about 27 states that have these laws in effect, but how many states actually require that people subject to these restraining orders turn in the weapons that they already own? And you can see again that it's lower. It's a little bit more than half, but you can see there's a significant number of states. There's a gap here in that a number of states have these restraining order laws, but they don't have the surrender provision. And then how many states have laws that actually authorize law enforcement to go in and confiscate guns if the person does not voluntarily turn them in? And here you can see again it's a very, very low number. Only 2 or 3 states have that provision in effect. So it's important to recognize that it's not as simple as just passing these laws. Careful attention has to be given to what are the enforcement provisions that are present in the law in order to determine whether these laws are going to actually carry out their intended impact. So you may have heard classic NRA argument is that we don't need more laws, we just need to enforce existing ones. And is that true or not? I have to admit, prior to this study, I didn't really think much about it, and I just thought, this is just another slogan that the NRA is putting out. But after concluding this study, I actually believe that there is some truth to this. To a large extent, I think the NRA is right. But it's not as simple as just saying we need to enforce the laws we already have. We need to actually build enforcement into the existing law in order to allow law enforcement officials to enforce the law. So in other words, you can't enforce a law if the law doesn't specifically state that the law can be enforced. So we can't just say, okay, well, the laws are already there, we just need to enforce them. It doesn't help, because if law enforcement is not authorized to confiscate weapons, or if offenders are not required to turn them in, there's nothing law enforcement can do, no matter how much they want to enforce the law, or no matter how much we get on them to try to get them to enforce the law more stringently. So there's a measure of truth to what the NRA is saying, in that yes, the intent of the laws is already there, and we do have to enforce them better. But our conclusion is that in order to enforce them better, we need to think carefully about incorporating those enforcement provisions into the statutes so that law enforcement officials can actually enforce them properly. And I think the most important point that I want to emphasize is that really all these relinquishment laws are doing is ensuring that the intent of existing federal law is carried out. So, and this is why I made a point of going through the federal law background, because it's clear that the federal government's intent is to prevent both people who are subject to restraining orders and people who have been convicted of crimes of domestic violence from possessing firearms. That is the clear congressional intent. And all the state laws are doing, all these relinquishment laws are doing, is making sure that that federal intent is actually carried out. So in a sense, these are not new laws in a way, even though that it takes a new law and it takes a statute to get this done. But in essence, all this is doing is plugging up loopholes in the federal law that's essentially made the intent of Congress unenforceable. And so I think, in conclusion, that the strongest arguing point for these laws is that they are simply necessary to make sure that the intent of Congress, which has already been expressed clearly and has already been enacted into law, is carried out faithfully. So with that, I'm going to turn it over to my colleague, Dr. Rothman, for some comments, and then after that we will be happy to answer any questions that anyone has.
Great. Thank you, Mike. And Emily, just before you start, I do want to remind people that if they have questions at any point in time, they should please type them into the chat feature in the webinar screen, and we'll get to those questions after your presentation.
Well, thanks so much. I want to thank Mike for the opportunity to have collaborated on this research and for presenting it so clearly, and to the Robert Wood Johnson Foundation for supporting the work and inviting us to speak on this webinar today. So I'll just say that I'm speaking with two hats on. I am a researcher now, but in my former life, prior to grad school, I was a domestic violence advocate. I worked in a shelter. I would accompany women to courthouse in order to apply for restraining orders. I do remember one time when I was in the courthouse helping somebody get a restraining order, when her perpetrator came in to the building and tried to get through the metal detector with a firearm. So I'm able to think about this both from standing back and looking at the data, and also remembering what it felt like to be in the shelter or to be up close with people who were really living this as a lived experience. And what I would say, with both of my hats on then, is I think these data are extremely compelling, that we do need confiscation type laws in all 50 states. It is striking to me that we could reduce 120 deaths per year if we took action on that. And for each death, I also think about the fact that every time there is a domestic violence homicide, intimate partner homicide, there are not just those persons, let's say the children or their parents who are affected, their coworkers, but the neighbors and everyone in the entire community. The ripple effects are tremendous for each one. So there's just so much to me that's persuasive about why we would need to make those changes. The practitioner or advocate part of me also does want to, I guess, mention that, of course, restraining orders are not a perfect cure-all for everybody, right? So when you're in the moment with an individual person who may be experiencing domestic violence victimization, it's very much a case-by-case basis. There are some individuals who, based on the specifics of their scenario and the perpetrator characteristics, can be endangered if they are, if the perpetrator feels that they're being provocative or, gets upset by the fact that they're served with a restraining order, because that restraining order is just a piece of paper until somebody violates it, and then that's reporting to law enforcement. So I just give that caveat about restraining orders generally. But as a researcher, I can absolutely say that I think these data support the idea that we should have the laws at the state level, that we need to probably invest in training of law enforcement in order to understand, each of these restraining order firearms-related provisions. They need to know what they mean, but particularly when it comes to relinquishment or when it comes to law enforcement confiscating firearms, they need to know how to do that, why they're doing it, and they need to have advocates help them troubleshoot some of the real-world problems that can come up when they're trying to do that. I'm also really intrigued by Mike relaying to us that the NRA has said, it's not that we need more laws, we need to enforce existing laws. So that's great, and I'm wondering if there's a way to capitalize on that kind of statement in order to push for law enforcement to be explicitly authorized to confiscate firearms. And if there's creative ways that advocates can use that in some of their state-level campaigns to do this. So I guess that's really all that I would offer for right now, except to say that I hope that there are questions, or I hope that there is discussion, and that Mike and I are able to answer any questions or engage in a conversation with you all if you have thoughts about this.
Great. Thanks so much, Emily. So I will, again, remind our audience to please chat your questions for Dr. Siegel or Rothman into the chat feature. And to get us started, while other people may be thinking about their questions, I wondered if I can, especially based on your point, Emily, about the restraining orders and their enforcement as well, just to ask both of you to respond based on your research and your experience about recommendations beyond, potentially recommendations beyond relinquishment clauses and other strategies for reducing gun-related intimate partner violence or homicide, sort of the best practices or those creative strategies, Emily, you might have been referencing, that are successful.
So if you, Mike, I don't know, I can try talking about that first if you like, unless you have a thought.
Yes, no, definitely you should take that first, yeah.
Well, I don't know if people on the phone know, but Rhode Island just, I think, last week had a success in this area, and it after years of cultivating relationships with legislators and really talking to people about the importance of having firearm provisions and restraining orders, that finally took place and happened in Rhode Island. So there was a change in state law in Rhode Island last week, which is great. And I know from, in terms of strategy, how do you make these kinds of things happen? I think that kind of advocacy does take a long-term commitment, right? So you have to persist and hang in there. It really took them several years to do it. It's also about relationship building. So finding one key person who's in a decision-making role, let's say in the legislature, who is somewhat, even a little bit sympathetic. Maybe for a person, maybe they had someone in their family or a friend who experienced domestic violence, and though they wouldn't normally support this, they understand what you're saying. and then using that foot in the door moment that you have with them in order to start trust building and building a relationship. The other thing that I see that people have done very effectively is use something that we call agenda setting theory, which is basically a fancy way of saying make sure there's something in the local media or in the press every single day about this issue. Keep people focused on it because that does reach legislators. They do read local media. They are interested in finding out what's affecting their constituents, what are their constituents thinking. And so building up the capacity of people to keep attention focused on this issue, I think does go a long way to help changing those laws. And I guess the part that I was hinting at when I said something like being innovative is I was thinking, is there a way to partner with people that you wouldn't normally partner with? So even if there are people who are generally opposed, they don't want new gun control laws put into place, but they do see your point around, that it's better that there be this confiscation clause and restraining orders. At least you agree on that. Are there ways to partner with those people, work together, even though you might not normally? And it takes a fair amount of grace and courtesy to make those kind of alliances sometimes. But I think that advocates could do that.
And that was great, Emily. And I just want to add that one of the things that I think I learned from this research is that process is really important, and that it's not just about the laws, although having the laws is really the first step that allows the process to take place. But I think what's really important is building a procedure, a set of procedures that take place. And it, as Emily mentioned before, it involves law enforcement. It also involves the judicial system and judges. So, for example, California is a good example of a state that has put in an entire procedure. They don't just have a law that says what has to happen. They actually spell out the procedure. So, for example, there are time limits in terms of exactly how much time a person has before if they are, say, served with a restraining order, how much time do they have before they must turn the weapons in? How do they turn them in? Where do they turn them in? You could have offenders who actually are, it's not that they're not willing to comply, but they may literally not know exactly how to do this. How do you turn in your weapon? So I think having a process in place. Education is also important because in a lot of situations there's research to show that often judges aren't aware of what the procedures are. And it's also important that procedures be built into the judicial process. So at the time that a restraining order is served, there can also be a specific note that addresses the firearm requirement, the firearm surrender provision, and information provided about how to accomplish that. So I think that there needs to be, cooperation between advocates, not only between advocates and lawmakers, but between advocates, law enforcement officials, and the judicial system, judges, to facilitate, a smooth process, smooth and clear process by which the intent of these laws can be carried out.
Thank you, Mike and Emily. And let me build a little bit off of this point that you're both making about unusual partners. And maybe this time I'll start with you, Mike, because you, I think, have been very purposeful in your research about really considering the balancing of the interests of gun rights supporters with those of violence prevention advocates. And carefully framing, trying to actually change the framing about how we think about gun rights and the fact that this is not, we shouldn't criminalize this issue, right? And so if maybe you can talk, certainly both of you, but maybe Mike, you can start by talking a little bit about in this very polarized space, how we start to build relationships and work together across the, to bridge that space between, again, gun rights supporters and violence prevention advocates.
Well, I think that one of the things that we're finding from this research is that perhaps the laws that are most effective are laws that deal with firearm possession by people who are at the greatest risk of perpetrating violence. And laws that sweep extremely broadly may not necessarily be as effective. And as it turns out, that is exactly what the NRA and what gun rights groups believe to be, that they support. They are very adamant about protecting the rights of law-abiding citizens, what they call law-abiding citizens, to have their Second Amendment rights. But even the NRA has very clearly and unequivocally stated that people who go afoul of the law, people who break the law, should lose their ability to have, they shouldn't have weapons. So there is a lot more common ground than I think is typically thought. And I think that gun owners in particular, and even some gun rights advocacy groups, could eventually be brought on board with some of these concepts. I think that they support the overall concept that people who are of the greatest danger should not have firearms. And I think it's possible to actually be more specific in our identification, more effective in how we identify people at the greatest risk. And the more effective we can be in making that identification, the more specific our laws can be. And in fact, if anything, we can actually enhance the right of people to own firearms, people who are law-abiding and who follow the law. I think that the one thing that I've realized from this research is that the greatest predictor of future violence is past violence. And the area where that seems to come out, the area that is the most sensitive to that is, I think, how people treat their partners. People who have any kind of violent tendencies, most of the time it's going to come out first with the partner. And I think this is why we're finding that there's such a huge decline in homicides, which is, it's remarkable. I mean, for us to be able to measure a 15% decline in homicides is a pretty remarkable finding. And so I think that's why. I think it's because this is the first sign. This is the sign, the most sensitive sign of a high risk of committing violence. And if we're able to intervene at that stage of the game, we're able to have a huge impact. So I think it's, I welcome your question, Aaron, because I think it makes the point that in no way is this interfering with anyone's rights to own a firearm. In fact, this is the exact opposite. This is going to the extreme. It's taking people who are at the greatest risk of committing future violence and basically making sure that they don't have the weapons that could lead to violence. And it really is not impeding anyone's constitutional rights. And if anything, it might actually make it easier for people who are law-abiding to obtain firearms.
Great. Thank you for that, those details. Emily, do you have anything you'd like to add?
I think Mike was comprehensive, and I'm actually just curious to know what others are thinking or if there are any other questions out there about it.
Yeah, absolutely. Please, again, to our participants, please feel free to chat in your questions or your comments into the chat feature. As we're waiting for that, I think your point, Mike, about sort of intimate partner violence being the first place where you might see violent tendencies arise raises another question about whether there's anything in your research that might suggest that reducing gun-related intimate partner violence or homicide, which I know was the focus of this study, influences the incidence of other forms of intimate partner violence. So whether you know through your research, or Emily, whether you have experience with in your background about how these laws that are focused on guns are impacting then other violent acts in intimate partner relationships.
So I can, why don't, Emily, you want to take that one first, and then I can share some results that we have from a little broader research that we're doing.
I was actually thinking if you want to tackle it at the big picture level first, that's
okay.
Good, and it also buys me a second to think of exactly an anecdote that helps illustrate what I might want to say.
Okay, so yeah, so Erin, it's a great question, and in fact, we are starting to look at the relationship between these laws, which are primarily designed to protect victims of intimate partner violence or potential victims. But we're looking at the effect of these laws on overall firearm homicide rates. So that's kind of the next step of our research. And I can share that our preliminary results are showing that these laws actually affect not just intimate partner violence, but overall homicide rates. And so there's an effect that goes beyond just protecting the intimate partner, that because the guns are taken away from people who are at the highest risk for committing violence, they're at risk not just to commit violence. Obviously, their partner, or dating partner, or spouse, ex-spouse, whoever it is that the partner is at the greatest risk. But these are people who, in general, are at higher risk of committing violence. And so we're starting to see an effect more broadly in terms of an overall effect in reducing overall firearm homicide. So I think that we may end up finding, although this is still preliminary, but it may turn out that these laws do have a much broader impact that goes beyond just protecting the 120 lives that we're talking about of potential intimate partner victims, but to actually providing a broader protection for society as a whole. And I think that we are also finding a similar effect for laws that in general require or prohibit violent misdemeanants from possessing firearms. So in other words, it's similar to the domestic violence laws, except it holds for any violent crime, not necessarily an intimate partner crime. And those laws we're looking at, and again, preliminarily, we're finding an effect of those laws. So I think that the question is very insightful in that I can't definitively answer it, but I think that our preliminary research is suggesting that there may be a more broad effect of some of these laws.
Thank you for that, Mike. And I would just add to it very briefly that people have pointed out that a large percentage of the people who commit what is sometimes called mass homicide have a background of partner violence, and that sometimes it seems like, why wasn't this person flagged, given that there were multiple restraining orders taken out on them, and that should be a bigger indicator to people in terms of level of dangerousness, and that we might be able to even reduce some of these mass casualty incidents if we strengthened what we do with domestic violence perpetrators. So that was one. The other thought is, of course, about children and the incidence of homicide suicide. So many perpetrators of intimate partner homicide also kill themselves at the at that site, the site of the homicide, and also sometimes kill children or elders or others who are nearby. And so when we strengthen laws that are designed to protect victims of domestic violence from intimate partner homicide, we may also be protecting those other victims who are, I don't want to call them collateral victims, but that's the term that's sometimes used, that there are others, including the perpetrator himself, often, who are killed during these incidents, and that we could go a long way towards making communities safer for other people and everybody by thinking about these laws.
Great, thank you both. So I have one more question for you, and then we'll see if we have stimulated any conversation, discussion, comments from our audience. But if you can both speak to what you think the next and most important steps are for both policy or practice in sort of in light of these findings. And I just want to take a minute to remind people who are joining us today that this research really is, I think in some cases we think, sure, of course it's important. Enforcement is important, and how you build into an enforcement is important. But in terms of thinking about enforcement in the context of firearm laws, this really is groundbreaking research because, as many people know, there has not been funding available for gun violence research. We haven't had the data collected in the way that Mike has compiled it in a way that will allow us to do this sort of research. So these really are very new and important findings in the context of how we think about gun violence laws, policy, and then implementation of those laws and policy. So if, again, both Mike and Emily, you could speak briefly to what you think are sort of the most important next steps in the near term, and then sort of a longer agenda around if there's additional research, practice, education, et cetera, sort of the pathway forward at this juncture.
So, Emily, do you want to go first? Do you want me to start?
Well, it's a fun question because there's a fun question as much as it could be on this topic, which is not fun. But I would say that there's a lot to think about here, and I guess the part of it that's exciting to me is thinking there's so much more that we could do, and if only we had the opportunity. For me, one of the overlooked areas in this area of research is threats. So, we've been talking a lot about how firearms are used for intimate partner homicide, and that's what this study focused on. But there are so many people whose behavior is controlled and are living with chronic fear and have to experience so many other forms of abuse because they live in constant terror that somebody may use a firearm against them because they're aware that one is in somebody's possession in the house or they've been threatened with it. And so, taking it a step further would be figuring out, are we also having an impact not just on homicides, but non-fatal events as well as threats, which I think have a profound impact on people's health and day-to-day well-being. So I guess my vote would be threats. That's what I would say, and I look forward to hearing what Mike says too.
So I guess I'll break it down into research, policy, and practice. So if you ask any researcher what the next step is, the researcher will always say more research. So I do think that in this case there is more research that needs to be done. And I think one aspect of the research that's important is to do actually qualitative research. What we've done here is quantitative, but I think there does need to be qualitative research looking at the process by which restraining orders are served, by which people are, the courts deal with convictions for domestic violence, and building in processes, doing research to try to find out what are the gaps, why is it that firearms are not being surrendered or confiscated. There is research that's been done showing that a very high proportion of people who are convicted of domestic violence are still in possession of firearms. And the question is, why is that? What are the loopholes? So I think there needs to be qualitative work to really understand that. Secondly, I think that we hope to extend our research further. We kind of only went one step along this pathway looking at surrender provisions, but there is the next step, which are confiscation provisions, and a number of states have enacted those laws. So one of the things that I'm hoping that we will be able to do next is to look at those confiscation laws and to see whether they have an impact. It's a little bit more difficult because there are fewer of them, fewer states that have passed those laws. So it makes it a little bit harder to have enough of a sample to get meaningful conclusions, but it is something that we want to look at. And then third, in terms of the research, is, again, I think to look more broadly at how violent misdemeanors are handled, because that is an opportunity to intervene with people who are at the highest risk. And surprisingly, very few states have laws that require, that prohibit firearm possession by people who are violent misdemeanants. So basically you can go out and assault people, commit violence, and as long as it's not a felony, as long as it's just a misdemeanor, you have no problem keeping your firearms or buying more firearms. So that's something that really strikes me as an area that we can look at more broadly. And then in terms of I think policy, the implications are pretty clear, that policymakers really need to look carefully at building enforcement provisions into the law. And then in terms of practice, I think there are really two things. One is working out procedures to facilitate the notification to offenders of what the law is regarding firearm possession. For example, there are states that have basically cards that they give to a person if they're either convicted of a domestic violence offense or if they're served with a restraining order. They're given a little card, and on the card it says, you may not possess a firearm, and here's what you have to do. You have to hand them in. Here's the address. Take them to this address. You have 48 hours. So it's making it easier in a sense for them to comply with the law. But I think that a lot of it also has to do with just education and public awareness. As Emily talked about before, keeping the issue active, keeping it on the agenda so that people think about it, and educating people, whether it be law enforcement, judges, so that they understand what the importance of this, really educating people about why this is so important. It really is an amazing, it's just this research, I can't emphasize how astounding it is to find such a huge effect. And I think what this is telling us is this is an incredible moment of opportunity. And you don't get a lot of those in public health. You just don't. And so when you have one, it's really imperative that you seize the occasion and use it to maximum effectiveness. And so I think that combination of research, policy, and practice is really a breakthrough in a sense, in that we've identified an area where we can really seize the opportunity to have a major impact on not only mortality but on quality of life.
Thank you, Mike and Emily. I totally agree. I think this is an exciting opportunity, and in particular, an exciting opportunity to bridge that divide that has been, I think, unfortunately widening between gun rights supporters and gun violence advocates. And so that's another area where I see there's this great opportunity based in particular on some of your findings, Mike, that maybe there is some truth to the fact that we don't necessarily need to pass more laws. We just need to have better enforcement and implementation of the laws that we have in place. So I do want to thank both you, Mike and Emily, for joining us today and sharing your research and your thoughtful insights into the development of the evidence base and strategies for reducing gun-related intimate partner violence and homicides. I also want to thank our audience, those of you who were able to join us today, you can find more information about this research, including a link to the paper itself and the archive of this webinar on our website at evidencefораction.org, where there is also additional information about our other grantees and our grant funding opportunity more broadly. And you can also connect with us on social media and through a variety of options as you see here. Thank you again to our audience, to our speakers, and we appreciate the opportunity to share with you this really important work.